Thank you, my lord. Before the short adjournment, I've been adopting a contractual analysis in relation to a gaming contract using a non-neg as opposed to a gaming contract using a cash chip, comparing and contrasting the two, an analysis similar to that adopted by Lord Gough in Lipkin Gorman. And I was about to then go on to consider the way in which the Crown put their case. And
just before you do that, could you just go back to Lipkin Gorman for a moment? Does it have any implications for your not drawing a distinction between cash chips and non-negotiable chips? Free cash chips, I mean.
No, it doesn't, because if we look at the cash chip given for free, the equivalent of giving the player in the casino £100, say in the case of a £100 chip. If the player chooses to use that chip to play a game rather than buy champagne at the bar, when the player puts that chip, stakes that chip on the table, say on red or black in roulette, at that point the casino are in a very real sense appropriating value to the chip, to the stake.
From?
From their own pocket in that example. But it's money that they've already given away. When they give the cash chip to the player, they say, here you are, have £100.
So you're notionally crediting, in the Lord Gough's analysis, you're notionally crediting to the punter's account the value of the chip.
Absolutely, absolutely. So this is why the my analysis in relation to the cash chip given away free is perfectly consistent with what I call Lipkin Gorman analysis, and indeed with an Aspinall's analysis, which we're going to go on to look at.
Right, but there is no cash in that situation.
Well, there is, because as Lord Gough, the very point made by Lord Gough in Lipkin Gorman is that the chips are nothing. Well, the chip is actually cash, and indeed the way that Mr. Justice Briggs, as he then was, put it in the upper tribunal in Aspinall's, was that chips are a little bit like, he called it private legal tender in use in the club.
So the free voucher,
which
the person has not placed any cash at the cashier's desk for, is not cash. It's not actually cash, to use your words a moment ago.
It is, my lady, for this reason. The player, once they've been given that chip, they could do one of three things with it. Of course, they could gamble, they could go to the bar and buy food and drink, or they could take it to the cage, the cash desk, and they could say, here's the chip, I will have £100, please. And they could take that £100, they could use it to pay for the taxi home. So it is cash, and it does represent cash that is sat in the safe behind the cash desk in the casino.
Fine. And your concession, as it was called this morning, was that it should be treated in the same way as the non-negotiable?
My concession, as it was called, and it was a real concession, I think it's a natural consequence of my analysis, but it's that the cash chip given to the player for free, which the player uses as a stake, it leads to the same gaming duty consequences as the cash chip obtained by the player when they actually turn up at the casino and deposit money behind the cage.
It's the same as a normal chip.
Same as a normal chip. It is a normal chip. They just got it in a different way.
It's as if they've been given £100.
Absolutely.
And gone and bought it.
Yeah, absolutely. We just short-circuited that bit. Rather than saying, look, there's £100. Here is a bit of plastic, which actually is worthless in itself, but is tantamount to being given £100.
Thank you.
So we'd looked at the contractual analysis applicable to the use of a non-neg and the use of a cash chip, compared the two. Which brings me to the Commissioner's case. And it's a recurrent theme running through their written case, but we see it most clearly set out in paragraph 1. This is MS page 52. And about halfway down that paragraph, there's a sentence beginning the key features. Where the key features of a non-neg are A, that when staked in a game, it's treated for all purposes in the game, and in particular the calculating payouts, as a cash chip having the value stated on the chip. Now, the problem with that approach, the reason that approach is plainly wrong, is that it ignores the fundamental differences that exist, the fundamental contractual differences that exist between playing with a non-neg and playing with a cash chip. The difference is that I ran through with you before the short adjournment as part of my Lipkin-Gorman or Lord Gough-based contractual analysis. The Commissioners, in their case, there are multiple references as well to what they call the rules of the game. This isn't a magic formula. The rules of the game are simply the terms of the gaming contract that exist between player and casino. It calls for a contractual analysis. As for the calculation of payouts that the Commissioners rely on in that paragraph we've just looked at, well, the difficulty there is that the Commissioners focus exclusively on the role of the stake in the game as a numerical value, and they ignore the requirement that the stake also has to have economic substance. Tying it back to the legislation, they ignore the need for the stake to have a value in money or money's worth, which we say is lacking in the case of the non-neg. Moreover, that approach to the identification and valuation of a stake based on economic substance was also the approach that the Court of Appeal adopted in its judgment in Aspinall's. The issue, of course, there was whether the player's entitlement to commission reduced the value of each stake staked by the player. And the Court of Appeal, of course, held it didn't, on the grounds that the player was playing with ordinary cash chips, in that case, equivalent to money. And it was irrelevant that some of that money might at some later stage be returned to the player. The court's conclusion was that gaming duty applied to the real economic value risked by the player in the game, so on the turn of the card or spin of the wheel, and the later right to commission had no bearing on that. And we see that from the judgment. If we can turn back to Aspinall's, please. Authorities tab 8, MS page 331. But can we pick up at page 335, please? And if we look at paragraph 6, where Lord Justice Moses sets out my submissions in that case, he said, Mr. Hitchmo, on behalf of Aspinall's, submitted that the value in money or money's worth of a stake staked was the value which the player risked. It was not, accordingly, necessarily the face value of the chip. On the contrary, the value of the stake staked had to be determined by reference to the contract between Aspinall's and the player under the cash chip agreement. The value of the stake staked by the player who had entered into such an agreement was therefore the value of the stake less any commission due to him under the agreement. Now, the court rejected that argument, but its reasons for doing so are instructive. If we look first at paragraph 7, contrary to Mr. Justice Briggs' criticism, this argument doesn't depend on a perception of value to the player or value to the banker. It's consistent with the objective ascertainment of value assured by section 1110A. Now, just pausing there, the point made there is an important point. a contractual analysis in order to identify and value a stake is consistent with the objective ascertainment of value that the legislation requires. Now, of course, that reflects Lord Gough's approach that we've looked at in Lipkin-Gorman. You already have my submissions on the fundamental differences that exist between the gaming contract entered into by a player who wants to play using cash chips and the gaming contract entered into by the non-neg player. Now, if we read on in 8 then, where his lordship explains why the taxpayer's arguments should be rejected, he says in 8, but I reject Mr. Hitchmo's argument. He says section 1110A is clear. The value in money or money's worth of the stakes staked is the face value of the chip. Okay, but why? Staking a chip is the same as staking money, and the value in money of the chip is its face value, and then reference to Lipkin-Gorman, the passages we've looked at. The stake is the amount risked in connection with the game. It's the value of that stake which is put at risk in the game. The value put at risk in the game is not altered by reference to any commission the player receives under the cash chip agreement. Now, those last 2 sentences of paragraph 8 are particularly important. The stake is the amount risked in the game, and in the case of a cash chip, such as the chips in issue in Aspinall's itself, the amount risked in the game was the face value of the chip, because staking such a chip was the same as staking cash itself. That reflected the terms of the gaming contract under which the cash chip was employed. And the terms of the commission agreement formed no part of that contract. That's why I lost. And repeat once again, the terms of the gaming contract entered into by a player playing with a non-neg are fundamentally different.
Where do we find them? Where do we find the terms of the gaming agreement with a non-neg?
Well, if we're... The answer varies depending on the sort of non-neg, my lady. But if we're dealing with the voucher, we've looked at those. They're the non-negs that have terms printed upon them. We'd look to whatever is printed upon the voucher. A little bit more complicated in the case of the non-neg chip, because, of course, that simply says non-negotiable on it. So in order to determine or understand the terms of that contract, we would have to have resort to the understanding of the parties. But it's quite clear, one thing that is quite clear is that the deal, the contract, entered into between player and casino, or player and banker, when a non-neg is employed, is come and game for free.
Sorry, gaming for
come
free?
Come and game for free.
But they were not asking that question. We were asking what is the value of the stake.
What is the value of the stake? The way I put it answers that question, my lady. Come and game for free. Come and game without any exposure to your pocket.
But it's critical to the player, is it not? You can tell me, because I have no personal experience, that he knows what he's putting in there, because that will tell him what he's going to win or what he's won on any given set of facts. He's got to know the stake.
What we're looking to value is, well, the value in money or money's worth of the stake. Now, those words staked is, we're not looking at what he's going to win, we're looking at what he's willing to risk, or she's willing to risk.
Yes, because that's a factor of what he's put in as a stake.
Well, it may or may not be a factor of what they have put in as the stake. I mean, we would say here, put nothing in as a stake. We will pretend that you've put something in as a stake, with a view to giving you a prize if you make the right prediction on the outcome of a spin of a roulette wheel, say. But what the legislation, Lipkin-Gorman, Aspinall's, the way they all point is that when we come to value the stake, we adopt a real-world economic analysis. The way Lady Justice Gloucester put it in paragraph 29 of her judgment that we went to this morning. We don't apply a notional or philosophical value. We keep our feet firmly on the ground.
You're going to come to the question of whether or not you could give your non-negotiable chip to
I am.
somebody else.
I am. Because, I come to broad-heading valuation. I am going to come to that. What I wanted to deal with first, though, if I may, my lord, is the diamond necklace example, because it feeds into the whole valuation question. And that's where I was going to turn next. If I've, my Lady Arden, have I answered?
Well, I didn't think philosophical values came into gaming.
Absolutely, that's the very point that Lady Justice Gloucester...
But I wasn't putting to you that it was a philosophical value. It's actually printed on the voucher.
Well, it is the value that this thing shall be treated as treated as having for the purpose of calculating winnings. But that's a very different thing to saying, well, this is real economic value, value of substance that is being risked in the game. Value in money or money's worth. Keep coming back to those words, in money or money's worth, because they're so important. Value in money or money's worth employed in the game, risked in the game.
Thank you.
And the point may become clearer, actually, as we work our way through the diamond necklace example that's relied on by the revenue, an example which we say is misconceived. The diamond necklace is quite obviously money's worth.
Sorry, I thought that the point of the example was that it may not be.
Well,
I mean, if it's valueless, is it money's worth?
Well, you say valueless. Even the necklace where the stones are made of paste will have some value. It's costume jewellery. It will have some value. Just bear with me.
All right, sorry.
with this. No. And this is where Lydia Sean comes in as well. So just bear with me. So, but in the ordinary case of the diamond necklace, not the one with the paste stones, the one with real diamonds, quite obviously money's worth. So a charge to gaming duty should arise if it's staked as a stake in a casino game. But as the revenue recognised, the actual value of the necklace could fall anywhere within a relatively broad range. So the question then is, well, how do we go about calculating gaming duty? And the answer is that in practice, it should cause no difficulty whatsoever. And that's because, as Lady Justice Gloucester recognised in that paragraph 39 of her judgment you were taken to this morning, it's MS 110, the value of the necklace as a stake in money or money's worth would necessarily, she said, be a matter of agreement between the player and casino before it was staked. So the value in money's worth of the necklace as a stake would be one of the terms of the gaming contract entered into between player and casino. And as Lord Justice Moses recognised in Aspinall's, an agreement of that nature is, he said, consistent with the objective ascertainment of value assured by section 1110A. Now, if it later transpires that the necklace is worth more than the value agreed, it simply means that the players entered into that bargain. But as the revenue accept, there would be no need for the casino to revisit its liability to gaming duty in those circumstances. You stick with the terms of the contract. By the same token, the casino would be unable to do so, revisit its liability, if it turns out that it's the one that's made the bad bargain by overvaluing the necklace. The casino, again, is stuck with the terms of the contract. But, of course, that's all irrelevant to the present case, where the player playing with a non-neg risks nothing of value in money or money's worth. Subject, I accept, dealing with Lord Kitchen's point, to be making good on the submission that the thing is not assignable for value in money's worth.
But I'm struggling a little bit with the last sentence of paragraph 39, Lady Justice Gloucester's judgment, page 110, where she seems to detach the actual value of the necklace from the real world and says that it's going to have the value that the parties assigned to it. Now, why doesn't that reasoning apply to the non-neg chip? Okay, it has no value in the real world, but the parties assign the value of £5 to it in the game.
Well, what we have to identify is the agreed value in money or money's worth that the parties accept is being risked in the game. The agreed value of the thing being risked in the game. And in the case of the non-neg, something that clearly has, sorry, not the non-neg, in the case of the diamond necklace, something that clearly has a value, the agreement is, well, £10,000 or whatever may happen to be the terms of the agreement. But the non-neg is fundamentally different. The deal with the non-neg is come and play for free. Come and play without putting value at risk. You've not had to deposit anything with the club.
But it is what's happening with the diamond necklace when the two parties agree the price, that you're in fact fixing a notional market value, because you've got two opposing points of view and they have to meet in the middle.
I would agree with that, save one word that you use, my lady, the word notional.
Yes. Yes, all right. Right. I agree, yeah.
So, other than that...
Take that away.
Yeah, take that away. And put that word back in if we're dealing with a non-neg. Because the value is entirely notional. And that's the difference between the two. And analysing both the transaction involving the diamond necklace and indeed the transaction involving the use of a non-neg in that way actually finds further support in the approach adopted in Lydia's Sean. Lydia's Sean can be found at Authorities 11, that's MS 380. Now, the case itself was concerned with the old charge to gaming licence duty under Section 14 of the Betting and Gaming Duties Act 1981, although that legislation was, for present purposes, material identical to that we're concerned with. If you look at MS 384, please, you'll see the legislation set out. Page 131 of the report, MS 384. Cast your eye over it, you'll see the structure of that legislation, the notion of profit or banker's profit, mirrors the one that we're grappling with.
Sorry, where does one pick up banker's profit?
I just wanted you to look at the legislation in the first place at the top of page 384 between letters A and D, because just to make the point, or so you appreciate that it's the same as our legislation, or materially the same as our legislation.
Yes, thank you.
Now, the issue in Lydia's Sean was whether the appellant casino was liable to duty on chips lost to the house in circumstances where the chips had been exchanged for a number of forged bank drafts, to the tune of, I think it was about £10 million in the case, huge value. But the outcome of that issue turned on the question whether the casino had accepted the drafts as absolute as opposed to conditional payment for the chips. If it had accepted them as absolute payment, it was common ground that no liability to duty could arise under that banker's profit calculation. No liability could arise because the chips had not been issued for a value in money or money's worth. And we see that common ground set out at paragraphs 5 and 6 on page 383. So you see, the appellant's case is that the cheques represented absolute as opposed to conditional payment for the chips, but that Mr. Elshamlin, he's the gambler, Mr. Elshamlin's signature did not constitute endorsements, so that there was no underlying loan on the issue of the chips. It was common ground that if the cheques represented absolute payment and were not endorsed, the sum represented by the lost chips did not form part of the appellant's gross gaming yield within section 14.2, since the chips were not issued for money's worth, because the cheques were forged. Mr. Sells, or Lord Sells now, contended that the cheques only constituted conditional payment in respect of an independent underlying loan, and alternatively that Mr. Elshamlin backed the cheques so that they did not, I think actually the knots shouldn't be there, so that they did represent money's worth, notwithstanding that they were forged. Now, the tribunal concluded that the drafts had not been accepted as absolute payment, so the casino was liable to duty on the value of the chips lost to the house. That conclusion of the tribunal was then upheld on appeal by Mr. Justice Lloyd, as he then was. Moreover, you'll note that the casino there was liable to gaming duty on the face value of the chips staked with it, irrespective of the true worth of the fraudulent gambler's personal covenant. So irrespective of the actual value of the money's worth received by it in exchange for the chips. So this is an example of a case where, although the casino has received value in money's worth from the player, personal covenant, it's made a bad bargain, because Mr. Elshamlin's personal covenant was worth nowhere near the, I think, £6 million and odd pounds he actually lost to the casino. And it's a little bit like the revenues example of the diamond necklace, if it turns out that the stones are made of paste. Mr. Elshamlin being a man of straw. But that might be contrasted with the non-neg, because just like the forged draft accepted as absolute payment for an ordinary cash chip, the non-neg hasn't been issued for money or money's worth, and doesn't, for the reasons I now want to turn to, represent money or money's worth risked in the game. So I am now going to deal with the question that Lord Kitchen keeps putting to me about actual value risked in the game. So we've got litigation, and the basis of the common ground in litigation are consistent with our analysis of the gaming duty legislation, and indeed consistent with both Appellant and Lipkin-Gordon. Now, turning to valuation, as the Revenue recognise in their written case, and indeed as expanded upon by my learned friend this morning, there are at least two possible ways of testing whether a non-neg has an actual value in money or money's worth. And two that remain that we've not looked at already. The first is to consider whether the non-neg might be exchanged for cash, what the revenue call the encashment value approach. Included in that, using the non-neg to spend, to buy food and beverage in the club. And the second is to consider whether the non-neg might be sold or assigned for value in an arm's length transaction, what the revenue call the market value approach. And I just want to look at them each in turn. But just let me stress two things at the outset. First, the alternative approaches to valuation are not mutually exclusive, and nor were they treated as such by either the upper tribunal or the Court of Appeal. And second, really the point that follows on from that, the Revenue are wrong to suggest that there is some inconsistency between the approach to valuation adopted by the upper tribunal and that adopted by the Court of Appeal. And I can deal with both of those points together. If we can look first, please, at the approach of the upper tribunal, starting at paragraph 26 of its decision, which is page MS 128. In 26, it sets out its conclusion on the issue before it. It says, in our judgment, both the legislation itself and the authorities support the argument that the value of the stake staked is the amount which is put at risk by the player when staking the stake. That amount is the real amount of money or money's worth that's risked in the game. It's not any notional amount represented by the face value of the stake. So there we see the conclusion. And what the upper tribunal then does, it sets out its reasons for arriving at that conclusion. And in doing so, it first of all considers the encashment value approach to identifying money or money's worth. And we see a good illustration of that in paragraph 27. It's a paragraph I took you to this morning. I don't know if you want me to take you through it again or if you recall. So that's 27, but then at 34, the upper tribunal goes on to consider what the revenue termed the market value approach to valuation. So on the other hand, the objective valuation of a stake would, in our view, have to have regard to the monetary value of any that could be obtained on an arm's length assignment to a third party at the right to place that stake in the same way that it would if the non-neg was redeemable for cash or for goods or services. That would be money's worth for the purposes of Section 1110A. It was not, however, the revenue's case that the stakes of the non-negs should have any value other than the face value of the non-negs, and there were no findings of fact, either that the non-negs were transferable, or if they were, what value might be realised on a transfer. Furthermore, as Section 1110A requires the individual stake to be valued, there would have to be evidence of a value generally obtainable in the market in non-negs, or evidence that a particular non-neg could have been, at the time it was staked, assigned for money or money's worth. In the absence of such evidence, it's not possible to ascribe any money's worth to the stake by reference to any assignable right.
So the upper tribunal do seem to be assuming that something has been staked. I mean, that seems to be...
They do assume, and indeed before the upper tribunal, it was a question put to my learned friend, I did accept that something had been staked, and indeed that's recorded by the upper tribunal in its decision at, so let me take you to it. Yeah, paragraph 17, MS 126.
Yeah.
First sentence.
I also wanted to ask you about paragraph 34, where again the tribunal...
We'll come back to the...
Right, well, let's finish. Can we finish the staked bit?
Yeah.
So what happened in the Court of Appeal? Because the Court of Appeal said no stake, nothing was staked. There wasn't stake.
Oh, no. Wait a minute, bear with me. So what the upper tribunal does, it recognises two possible ways in which you could go about valuing a stake, determining whether the non-neg has real economic value. The first is to consider whether encashment. Can you take it to the cage and swap it for cash? Use it to buy goods and services? No. But that's not a complete answer, they say, because you've also got to consider whether it can be assigned for value. And that's what they go on to look at.
Sure. No, I follow all of that.
Yeah.
But, sorry, I was on the prior point, because the Court of Appeal in its reasoning says, well, actually, there wasn't a stake here.
Absolutely.
But I just wanted to know how we got to them saying that when you had conceded in the upper tribunal that there was a stake. Did you withdraw that concession?
That came for the first time in the Court of Appeal's judgment, my lord.
Right. Okay. So your case, as you were running it, was essentially the same as in the upper tribunal.
It was a value case. Yeah.
All right. And sorry, just so that I can get it clear, are you seeking to support that part of the Court of Appeal's reasoning where they say there wasn't a stake now?
Yes, I am now. Indeed, the agreed issues before this court, are whether there was a stake, and if there was, whether it had value. You'll see that from the statement of facts and issues agreed before this court.
Okay. So I suppose strictly you need our permission, is that right? Well, I don't know, because the Court of Appeal actually said...
it's what the Court of Appeal actually said, but in many ways the point is largely academic, my lord, and the reason I say that, it's a point my learned friend made this morning. The court's conclusion on stake and its conclusion on value really go hand in hand. They march hand in hand.
Yes, thank you. That's helpful. And then, sorry, I diverted you from paragraph 34.
So the point I was making, the upper tribunal, it looked at encashment value. It said no encashment value, but that's not the end of the story. Do these things have a market value? Can they be assigned? No evidence of that. So conclusion, no value in money or money's worth. And we see that if we look at paragraph 35, it's MS 130 again, just picking up at line 33 on the true construction of that provision. So this is section 1110A. On the true construction, the stake staked by the non-negs did not represent any money paid or deposited with LCM, nor did they have any value in money's worth by reason of their being redeemable in money, or for goods and services to a monetary value, or, on the evidence, otherwise assignable for money and money's worth, consequently value nil. So the upper tribunal there had in mind all possible bases of valuation, and it said, look, whichever way you want to skin the cat, whichever approach you adopt to valuation, these things do not have a value.
But it makes quite a big difference saying that the market value, they're driven to that conclusion on the evidence, because the Court of Appeal seems, well, more particularly if they, as you say, run their idea of stake with the idea of value, seem more to treat it as a point of principle that it could not.
I want to look at the Court of Appeal next, because I'm not sure that's really right, my lord, because if these things were assignable, if I had one of these things and could assign it for value, if I choose to risk that thing in a game, well, of course, I'm risking value in money or money's worth as stake. Of course, I'd accept that.
So, sorry, just so that I can be clear, you're accepting is this right, that it may be on the particular facts of a particular case that a non-neg could be regarded as having market value, and that would be the money or money's worth that was staked.
If it was assignable, right? If it was assignable, then it clearly has a value in money or money's worth. And I say in money or money's worth because it might be converted into money. Now, what is that value? And the revenue said, we may need to get into this fancy valuation exercise, which would cause all kinds of difficulty. Well, no, it wouldn't, because we go back to that contractual analysis. This is why the diamond necklace example is actually not a bad one. We look at the deal, the terms of the contract agreed between player and casino. So insofar as actual money's worth has been provided, we look at the value attributed by the parties to that money's worth, which will be the face value of the non-neg.
So the face value of the non-neg?
Yes. Because in that case, the non-neg...
I'm sorry, so to be absolutely clear, you're accepting that if it were possible to transfer this non-neg from one punter to another, say for payment of half the value by the person receiving it to the person who's transferring it, that would be a transfer for value which would indicate there were a value in the non-reg, and you would then revert to the face value.
Well, you then got, once you've identified value in money's worth, which we have there because the thing's assignable, once we've identified value in money or money's worth, we say, well, how do we go about ascertaining that value in money or money's worth? It's no different to the diamond necklace. What is the money's worth of the diamond necklace when used as a bed? And we look at the terms of the contract agreed.
But they're different contracts. In the one case, you've got a value as between the punter and the casino, and in the other case, you've got a contract between the two punters.
No, it's always contract between punter and casino, my lord, unless I'm misunderstanding, because what we're looking at is in the case where it is transferable, one punter transfers it to another in return for payment. Sorry, I'm misunderstanding. With the thing that's transferable, the non-neg that's transferable,
Yeah.
I decide not to transfer it. I'm going to use it as to play a game.
Right.
And the question we're then asking is, well, what is the value of that thing, that voucher? What is its value as a stake? And the fact that I can transfer it merely tells me that it must have some value. Now, the question then is what value? And we look at the terms of the contract.
It depends on the value to whom, I suppose.
Well, objectively, the voucher has value because it might be assigned for value. Now, we don't know how much. It's a bit like the necklace. We don't know quite how much I'm going to get for the necklace if I put it into the auction at Bonhams.
Sorry, you just said the voucher. I think you mean the chip, the non-neg chip.
Well, chip or voucher, yeah. The non.
Maybe a
I mean
difference
the non
between the two.
Yeah.
So why would Parliament want you to apply an open market value or a value between parties who are not parties to the gaming contract of something which has been made a stake?
No, we only look at the parties to the gaming contract. So the reason this thing has value in the first place is because it might be sold. It might be realised for value in the same way as the diamond necklace.
You seem to be saying that provided that there's some market value, however small, associated with the thing that's being sort of put on the table, either the paste necklace or the non-neg chip, once that sort of initial hurdle has been overcome, then it becomes a matter of valuation as between the casino and the punter. Well, here's an item of uncertain value. What value shall we ascribe it in the game? It'll be the 10,000 for the necklace or the face value of the non-neg, even though that's different from what the person might have been able to step out into the market and sell it for.
Yeah, we don't get into that. Yes, that's absolutely. That's precisely the point, my lord. We don't get into this complicated question, this complex question of what might I actually have got in the marketplace. We look at the deal between the parties.
All right.
But in that case, then,
sorry, my lord.
If on the second of the three scenarios put to us by the appellant, the revenue was inclined to accept, as I understood it, that it would lose the appeal were that the interpretation that we thought correct.
Yeah.
Because the revenue had put forward no evidence about the market value.
Yeah.
But you're conceding that in that case the revenue wouldn't lose because you would at that point accept the face value of the chip, which the punter could play for in the game.
Yeah, that doesn't follow at all, my lord. In this case, there is no evidence of assignability. Now, unless the thing is assignable, it cannot have a value in money or money's worth. So we don't.
Is there any evidence of non-assignability? I'm surprised that it's now all turning on this question of whether this chip is assignable in any sort of sense, which I didn't understand.
I mean, we've seen the pictures of the chips. They just look chips, even though they say non-negotiable. Yeah. So suppose I'm standing at the gaming table. I've got some non-negotiable chips. I'm feeling thirsty. I turn to the person standing next to me and I say, here's a £5 non-negotiable chip. Will you give me £4 to go and get myself a drink? I'll give you the chip. Yeah. He says yes. He plays the chip. We've seen nothing to suggest that the casino wouldn't accept that chip as played by him.
Rather, my lord, there's no evidence that the casino would. There's no evidence, or there was no evidence before the tribunal that these things were assignable.
Forgive me. We've got the evidence, but we've seen the picture of the chips.
Well, you've got more than that. You've got the witness statement of Mr. Rothwell as well.
All right, we haven't looked at that, but just pausing on the evidence of the picture of the chips. There's nothing on the face of the chips that would enable the dealer or whoever is playing the game on the part of the casino to identify that when the non-neg is put on the table, that the person playing it wasn't able to play it.
Well, say, my lord, that these things are not just handed out willy-nilly. They are handed out to known customers of the casino to enable that customer, or to encourage that customer to gamble in the casino. That was the evidence, the unchallenged evidence.
All right, so take my example. You've got two known customers, the high rollers who you want to encourage, both of whom might use a non-neg chip, and then play out my scenario. One of them has a non-neg chip, asks the other one, will you give me some money in exchange for my non-neg chip? The other one does, and then plays it. Again, there's nothing to suggest that the croupier wouldn't accept that chip as played.
There's nothing to suggest they would, my lord. I mean, the evidence is that these are aimed at particular players, a player who has to produce ID to prove who they are.
No, but that's to get the chip. I'm now talking about the stage where the chips have been acquired.
Yeah.
And we do have some evidence. We've got the picture of the chips. There's nothing on the face of the chips to say this chip belongs to Mr. Bloggs and can only be played by Mr. Bloggs.
No. You're right, my lord. We don't. But the Revenue Act said that absence evidence of assignability, of which there is none. This is a point my learned friend made this morning. Absent evidence of assignability, of which there is none, they must lose this appeal. And that was the very point that the upper tribunal made in paragraph 34 of its decision that we've just looked at. A paragraph that the Court of Appeal agreed with in terms, and we'll look at the Court of Appeal's judgment in a moment.
Well, paragraph 34, the last two sentences appear to be talking not so much about whether or not it were assignable, but whether or not, if it were assigned, what the value which the punter would have got for it would be.
With respect, my lord, starting at line 24, a particular non-neg could not have been, at the time it was staked, assigned for money or money's worth.
At the time it was staked. That was my point, that Parliament was asking you to focus on that very moment in time, in which case questions of assignability become academic.
No, they don't, my lady, because what we are trying to value is the stake, the value of the stake in money or money's worth. So at the point when this thing is placed on the table, this non-neg is placed on the table.
Well, why would Parliament want you to conduct this theoretical exercise of what it might be worth in the open market when it's being used and you're valuing it at the point of time when it is being used?
Well, there is no theoretical or hypothetical exercise, my lady, because if the thing has value, if the thing is capable of assignment, which it's not, see the upper tribunal, but if it's capable of assignment, it then has a value in money's worth. It might be converted into money. What is that value for the purpose of the game? We look at the terms of the contract agreed between club and player.
But that goes back to the point you made on the pace necklace, as I understand anyway, that if there's any value at all for the pace necklace in the market, that's sufficient then to take one into the agreed valuation for the purposes of the game between the punter and the casino. And well, certainly what I'm seeking to press you on, and I rather think others are as well, is if it is possible to assign the chip itself, take my example, I give it to the man standing next to me, he gives me some money. So for me, it does have some market value. Mm-hmm. When it's played, one forgets about its actual market value, as one forgets about the value of the pace necklace, and looks at the value assigned to that thing, which does have money's worth, so far as I'm concerned, as between the punter and the casino, in which case you just go back to the face value of the chip. So I am struggling to understand now what you're saying, because you seem to be accepting that the whole analysis turns upon whether the chip itself is assignable or not assignable. If it is assignable, and therefore has money's worth, represents money's worth, it doesn't matter what value it could be assigned for, because you've got over that initial hurdle that I just described, and then you're just looking at the value assigned to it as between punter and casino. We know that because it's the face value of the chip.
But before you answer that, can I just add in that before we were looking at something which had a symmetry between what the punter puts onto the table and what the banker takes off if he loses. But here, there isn't that symmetry, because as Lord Kitchen pointed out, the contract which fixes the value is not between the casino and the punter, but between punter and punter, because he assigns it.
No, it is between casino and punter.
Well, when he puts it on the table, it is.
Yes.
But what fixes its value is Lord Sales giving it to his next-door neighbour for £4.
No, my lady, it doesn't.
I mean, I'm getting a little confused by this, and certainly I'm losing track of how the assignability comes. Could you just formulate your position now clearly as between a case where it's assignable and a case where it's not assignable?
Yes.
And what is it due to the consequence?
Take first the case where the non-neg might not be encashed, might be neither encashed nor assigned. In that case, the non-neg has a nil value in money or money's worth.
Right.
For the reasons actually given by both the upper tribunal.
And then the other case?
Right. In the case of the non-neg that might be, well, let me take first the non-neg that might simply be encashed. That's easy.
Yes, that's easy. Right. The difficult one is
but there are three possibilities here. So then we move on to the non-neg that might not be encashed, but it might be assigned. Now, as the upper tribunal recognised in paragraph 34, it follows from the fact that the non-neg is capable of assignment, that the non-neg has a value in money's worth when used as a stake. But that then raises the question, well, what is the value of the non-neg when employed as a stake? And there are two possibilities there. Possibility one is that you call evidence of the nature identified by the upper tribunal in paragraph 34. Now, that's
possibility one. Possibility two.
Well, just let me say, that's unsatisfactory.
No, well, okay. I'm trying to get your proposition. We can discuss their satisfaction afterwards.
Answer two is we look at the terms of the gaming contract agreed between player and banker and value the non-neg, or attribute value to the non-neg in accordance with the terms of that contract.
Which is the face value.
Which is the face value.
Yes, I mean, in simple terms, all turns on assignability. If it's not assignable, then it comes as nothing. If it's assignable, it comes in at face value.
Yes. And here there is no evidence of assignability, as the upper tribunal noted quite clearly in the...
I mean, is there any evidence of non-assignability? I'm not sure that anyone actually called evidence on this point or cross-examined on it.
No, this is a point that was actually raised for the first time by the Revenue in the Court of Appeal, consequent on the upper tribunal's observations in paragraph 34 of its decision.
But I mean, the point raised by my Lord Sales is a pretty obvious point. Someone has one of these things and may exchange it with his neighbour for the cost of a drink. I mean, that's not out of the world scenario.
Well,
You say in that situation everything changes and suddenly the chip comes in at full value instead of being nil value.
Before this court, my lord, we have that the upper tribunal's observation that I took you to. These things are not capable of assignment, and the revenue don't look to go behind that or challenge it. They accept. Look, if assignability is the proper approach to identify value in money or money's worth, they accept that they must lose this case.
It's because there's no evidence of value. It's not a question of there being no evidence of assignability.
There's no evidence of value. Yeah, that's fair. Thank you, my lady. That's a fair way of putting it.
Yes, I am concerned by Trump being asked to decide this as a matter of principle in a matter which may well affect all sorts of other cases. So we don't want to get sort of hung up on a point which may be turned simply on the way the evidence is presented in this case.
I mean, the quick fix for the future in the case of the voucher is to print the words non-assignable on them.
But no, well, it's not the voucher. That's why I keep going back to it's the chip, which is actually what is played.
Might I just take you back, please, to this question of value? Because I understood from your earlier submissions that in assessing the value under subsection 10 of section 11, one has to look at the value that the player or the punter is at risk of losing. And it certainly on one interpretation of paragraph 34 of the upper tribunal's decision, the upper tribunal was concerned about the lack of evidence of such value. And as I understood the revenue's submissions this morning, they said, yes, in the context of this case, if one has to look at the actual value that is being risked by the punter, then we, the revenue, lose. You are not embracing that concession. You're saying that the fact there's no evidence of the market value of this, let's assume, assignable chip, doesn't harm the revenue's case because one simply then reverts to the value on the face of the chip.
I'm saying it does. It fundamentally undermines the revenue's case because absence evidence of assignability, the thing can have no value. Whatever the value, can have no value at all in money or money's worth. It cannot be converted into money, and we go no further.
Right, but then the case doesn't depend upon evidence being led as to what the value might be on assignment. It does look like a point of principle. Is it capable of being assigned? Because on the theory, as I think of it as the paste necklace theory, as you explained it to us, it doesn't matter what the thing is worth in the real world. It just has to be worth something, however small. And if you get over that hurdle, then one's immediately, on your theory of the section, into what the parties have agreed it shall be worth, namely the face value of the chip. But, I mean, I didn't pick up that this was the way the case was presented in the tribunals, which would look at the facts. And insofar as we look at, well, it does seem to make an awful lot turn on a point of fact which you say hasn't been investigated, but I've already expressed my concerns that we've got some evidence, we've got the chips themselves, which don't say they're non-assignable. I'm just slightly at a loss as to where you say we should go on this appeal. Are you saying that we should find as a fact that these chips are never assignable? I don't see how we could do that.
No, you should stick with the upper tribunal was a fact-finding tribunal. I mean, having identified an error of law in the approach of the first-tier tribunal, it was itself a fact-finding tribunal. And it couldn't be clearer when the upper tribunal says in paragraph 34 that the non-neg, or a particular non-neg, could not have been assigned at the time it was staked for money or money's worth.
But that's looking at the time it was staked. I mean, we were looking at a time before it's staked. In my example, I was anyway.
Well,
I have to
with
say
respect
that
to that, the time it was staked is the relevant time to focus upon, because it's at that point in time when that critical gaming contract is entered into. We're trying to identify the terms of that gaming contract.
Yes, thank you.
But your case on this is not consistent with, you and the Revenue are not saying the same thing about this at all, are you? They're saying market value as in the marketplace. You're saying face value of the chip in that situation.
Well, I'm saying you say, does this thing have a value in the marketplace in order to test the question whether
the
this thing...
signability.
Yes.
Yes, but when you come to value, as I've understood their case, they're saying it is the market value in the marketplace, and you're saying, no, you default straight away to the face value.
The reason they want to say, oh, well, it's the actual value in the market, because then they can make the submission to you, and look at the chaos this would lead to.
No, but I mean, I
No,
can't help thinking
very
they'll be
happy with your
they'll be delighted with what you're saying, just so long as they can show that it's assignable, because that avoids all the chaos, which is actually, speaking for myself, an attractive feature of your analysis. But it just seems to make your winning or losing depend upon a point of fact which hasn't been investigated.
And the figure's higher because you'll assign it for less than its face value.
Yeah, you will assign it for less than its face value, but...
So your arrangement produces more for the Revenue?
If the thing is assignable in the first place, and yes, it would, that is a consequence, but it avoids the unattractive result of having to adduce complex evidence on value.
But it removes the symmetry between what's put on the table and what the banker takes off it.
My approach doesn't. It secures that symmetry because we're looking at the value agreed between player and banker.
But I think we probably...
Okay.
But I mean, just on disposition of this appeal, I mean, if we're persuaded that it all turns on a question of fact, I mean, wouldn't the appropriate course be for us to remit the case to the first-tier tribunal to make findings of fact, as would then be relevant on this analysis?
With respect, no, my lord, we've got what we need in the upper tribunal's decision.
All right, thank you.
Right, where do we go from now?
Where we go, we've been looking at the approach to valuation adopted by the upper tribunal, and I said it considered an encashment value approach, and then it considered a market value approach. And part of the Revenue's case is that the approach adopted by the Court of Appeal was inconsistent, that the Court of Appeal had in some way done something different. And I just want to deal with that point. So, well, actually, the Court of Appeal approached this case in the same way as the upper tribunal. If we can go back, please, to the judgment of the Court of Appeal, which is turning to paragraph 36 of Lady Justice Gloucester's judgment at MS 108. She considers first an encashment approach to the valuation of the non-neg, paragraph 35. She considers first an encashment approach to the valuation of the non-neg. Non-negs are clearly not the same as money in the sense that cash chips are not a form of private legal tender. Non-neg can't be encashed in any circumstances or used to pay for food or drink. So she considers first the encashment value approach. But then, having dealt with encashment value, she recognises that the non-neg might still have a value in money or money's worth if it can be assigned for value in an arm's length transaction. So this is now paragraph 37. Well, paragraph 37, she goes on to set out a number of the key passages in the upper tribunal's decision, including that paragraph 34 we've spent some time on. before, at the end of 37, saying, I agree with this analysis, there was no evidence before the tribunal to suggest that the non-neg had any value in money or money's worth.
And to my point, well, there was. What do you say? There was the pictures of the chips. They didn't say couldn't be assigned. Well, on the face of them.
My Lord, can we go back just to deal with that point? I said there was also the witness statement of Mr. Rothwell, to which the non-negs were, or the photographs of the non-negs were attached. That witness statement starts at MS page 228. And you turn to first to page 229. He's considering here the non-negotiable chips. And paragraph 14, he says non-negotiable chips are gifted to selected players, or selected customers, at the casino's premises to encourage these customers to play, i.e. the customers to whom they are gifted. Free bet vouchers at 21, this is MS 230. Free bet vouchers normally sent to selected customers by either postal mail shots or emails, selected based on the nature of their promotional scheme and profiling information held on the customer. And then general points on non-negs at 37, this is MS 232. From a customer's perspective, nothing is put at risk when using non-negs, as they've not paid anything to receive the non-neg. The purpose of the non... Sorry,
that's another point which would appear also to have relied upon, namely that the punter is not putting anything at risk. But you accept that if it is assignable, the punter is putting something at risk.
The punter would be, but it's accepted here. This evidence wasn't challenged, that the punter was not putting anything at risk, and that, it, of course, is a consequence. So accepted that the customer has not put anything at risk. The purpose of the non-neg is a marketing device to encourage the customer, that customer, to visit the casino.
But, I mean, if I may say so, I mean, none of what you've shown us actually says the chip, once issued, is not assignable. Well, I mean, I follow that it's all targeted on people that you particularly want to encourage to come in. But once they've come in and they've got a pocket full of non-negs, there doesn't seem to be anything Mr. Rothwell says that they couldn't hand it in my example to the person next to them to use at the tables.
The evidence, the accepted evidence, unchallenged evidence before the tribunal is these things have got no value because the player doesn't risk anything. Now, it would have been open to the revenue to say, look, Mr. Rothwell, that's wrong, isn't it? Because the player could have assigned this thing. They could have said to their mate, look, I'll give you a chip, you give me £4 so I can go and buy a beer, I think it was in your lordship's example. Yeah. They could have cross-examined on this, they could have challenged this. They chose not to do so. And with respect, my lord, it's too little too late in this court, the highest court in the land, to say, to speculate on what might or might not have been.
But I think it was you who formulated the propositions in terms of assignment. So you've made it a focal point.
No,
Have I misunderstood?
I think you have misunderstood. I mean, the basis of the revenues case is they say, look, these things are to be valued by reference to the face value, because that's basically the value that's used to determine the value of prizes. If we're wrong in that, they say, well, these things cannot have a nil value, because as the upper tribunal recognised, if they're assignable, value may be the consequence of assignment. But the other point that the upper tribunal recognised, well, there was no evidence of that in this case.
I think it's very clear where we've got to, in the sense that your primary case is that if the revenue had wanted to make a point based on assignability, they should have made it before the tribunal. Where you've got yourself into possibly a bit of difficulty is then speculating on where that would have got them if they had made a case based on assignability. And what's confusing us is you then seem to come up with an answer which is more in their favour than they're saying. But I mean, on your primary case, you don't even go there because you say you've got to deal with it on the basis that it was dealt with by the tribunal, which was where the question of assignability didn't come up. And not just a question of assignability, the possibility of there being a value of these items which was reflected in assignability. And that's, I think, why we've got ourselves into a bit of difficulty.
I'd agree with that, my lord. I mean, the evidence before the tribunal, these things had no economic value, and the way the revenue put their case is, well, that's irrelevant whether that's got actual economic value. You just look at the value stamped on the face of a means of calculating winning. That's enough, they say.
They say it's the value of the stake as played.
Yeah. So that's the revenue's case. Now, these whole notions of economic value, or the revenue's reliance on notions of economic value, they cropped up really for the first time in the Court of Appeal. And they were prompted by that paragraph 34 of the upper tribunal's decision. But you have my submission. Once we've identified value on the basis of assignability, we then look to the agreement reached between player and casino to determine what that value is. Maybe the face value, maybe something else. It depends on the term of the agreement.
But on your case, that doesn't arise in your case.
No, absolutely not. Absolutely not. And absolutely not. My lords, my ladies, I feel we're now going round in circles really on the question of valuation. So what I'd like to go on to consider briefly, if I may, in the time I have left, is the valuation of a non-neg as a prize, because both parties agree that there should be some symmetry between the value of a non-neg when used as a stake and the value of a non-neg when used as a prize. And can I just emphasise 2 points at the outset? First is that this issue, valuation of prizes, doesn't arise in the case of the one-hit and cash match vouchers, which, as I've mentioned already, they're retained by the banker irrespective of the outcome in the game. The second point is that both parties accept there is a need for consistency between the value of a non-neg as a stake staked and its value as a prize in a winning game. Now, for the purpose of valuing prizes, you've seen that the gaming duty legislation applies the bingo duty prize valuation provisions found in subsections 2 to 6A of section 20 of the 1981 Betting and Gaming Duties Act. Applies that with any necessary modifications. And can I please take you back to that legislation, which is at MS 288, that's Authorities, tab 2. And if you look at subsection 4, you'll see that a voucher provided as a prize is taken to have no value in two alternative situations. The first is if the requirements of subsection 3A and 3B are not satisfied. That's why I want to turn first.
Just before we get into the detail of it, I was puzzling over this because section 20 is to do with expenditure on bingo winnings. So that seems to be a way of the bingo company calculating how much it's had to spend on the winnings which are paid out. I'm just been struggling to see quite how that meshes with section 1110 of our legislation.
Well, if we look at our legislation, let me turn
page 300
back to it. If you, so our legislation now in 1110B talks about the value of prizes provided, etc.
So is it focusing on 10B?
Yeah, it is.
And so does your argument proceed in this way? Section 20 of the 1981 Act is relevant to subsection 10B.
That's all it's relevant to. Yeah.
But you seem to be emphasising that there has to be symmetry with A, and therefore are you saying it's also relevant to A?
Well, relevant in this sense. If the application of the prize valuation legislation leads to the conclusion that a non-neg returned as a prize has a nil value, that's a good indication that it should also have a nil value for the purposes of Section 1110A, and indeed vice versa.
Well, may I ask why? Because Section 20, subsection 4 is a deeming provision. So you could perfectly properly deem something to have a nil value for the purposes of B without necessarily saying that same deeming should apply to A.
Well, my lord, both parties to this appeal accept that there should be.
I'm very concerned about us being driven by what both parties accept when it doesn't actually fit with the... I mean, this is a provision which applies to prizes, which are one side of the story. And as my lord says, you can have a deeming applied to one side of the story, but not to the other side of the story. And I can't see why we should be forced to adopt that simply because for some reason the parties have decided that's the answer. I mean, these are very difficult provisions at the best of time to try and see how they marry up, but I think we would like to have your submissions as well. If you say that's the correct analysis, well, let's hear why, but I'm not going to...
Well, I'll certainly give you my analysis on the prize valuation legislation and give you my submissions why the application of that legislation results in a non-neg returned as a prize having a nil value, and that's what I do want to explain to you. It's important I do that in the time remaining.
May I just, as I understand your submission, put quite shortly, it is that the non-reg should have the same value. Parliament must have intended that the non-reg must have the same value for the purposes of Section 11, whether it's being placed by a punter on the table in a bet, or whether it's being returned to the punter as winnings.
Yes.
And Parliament must have intended that in Section 1110, and so that is an indication as to how Section 20 should be construed in this context. Is that right?
Absolutely, my lord. And that is common ground between the parties.
With necessary modifications.
Yes.
Right. Well, I think I better register that I have some difficulty if that's the path, because the 1981 Act provision comes in after the original provision, Section 11, which to all intents and purposes was in the same terms that we have to construe now. Now, it seems very difficult to use Section 20 in a sort of general sense to say, well, this shows what Parliament meant all along, because it's no indication at all what Parliament meant in 1997. It's different if it's a deeming provision, which it seems to be, because Parliament can deem things which aren't in fact the case to be the case at any time it likes. So I am...
I must say I share those concerns, because 10BA is telling us that we've got to look to a provision concerned with valuation of prices and apply it for the purposes of this section, which one would assume meant you apply it when you're valuing prizes for this section. And if they'd want you to apply it for the purpose of valuing stakes, they'd have said so. So, I'm at the moment having some problems with this. I mean, it may not be necessary for your analysis, but we are being told it is, so we better...
Well, not so much necessary for the analysis, but I come back to the point that both parties agree that you should try and achieve symmetry between the two limbs of banker's profit, or the approach to the two limbs of banker's profit.
Right. I mean, as a general proposition, I can see that. Yeah. If we were looking at the 1997 legislation in 1998, I can see that.
Well, it was easy then, of course, as well, because it talked about valuing winnings in money or money's worth. The language was consistent then.
All right. All right, anyway, I think you seem to be repeating your submission
am,
that
really,
everyone agrees that it must be the case, but we've expressed our
I
reservations
suppose
about whether...
rather than say it must be the case, I'm not sure I can take the submission much further, my lord.
Anyway, how do you say section 24 comes into the picture then?
Section 20 comes into the picture because if we look at 1110B, we're told we have to value the prizes provided, and then 1110A tells us how we go about doing that.
Yeah.
We turn to those provisions in the 1981 Act, which is, they're the provisions behind tab 2 at MS 288. And when we turn to those provisions, section 20 of the 81 Act, if we look at subsection 4, it envisages two circumstances where a prize, a voucher provided as a prize, is to be taken to have no value. The first situation is if the requirements of subsection 3A and B are not satisfied. That's just what I want to look at first. If you look at subsection 3A, it refers to the voucher being used in place of money as whole or partial payment for benefits of a specified kind. And the first point to be made in relation to subsection 3A is that participation in a casino game using a non-neg doesn't involve payment for a benefit. Indeed, it's unrealistic to say that the non-neg is used as payment in circumstances where the non-neg is returned to the player if he or she wins the game.
But I mean, surely it is being used for payment for a benefit, the benefit being participation in a game where you can win.
Well, it's not being used as a benefit if, when I do win, should I win, I get it back. I'm not paid anything in those circumstances.
It was a condition if you're getting the winnings.
It's conditioned that I stake a stake, but I get the stake back. So in any real sense, I'm not paid for anything at all. I'm not paid for a benefit using the stake, so I get it back.
But it's to repeat the point.
Yeah.
You've used it to pay for a benefit, which is the chance of winning millions on the turn of a card. Why isn't that a benefit for which you've paid?
It is a benefit, but I'm not. The point is, I've not used the voucher or the chip to pay for that benefit, because I get the chip back. It's something I'm willing to risk, but I'm not using it to pay.
Okay, so that's A.
So that's the first reason why 3A is not satisfied. The second reason why 3A is not satisfied is the one identified by the upper tribunal at paragraph 49 of its decision, with which the Court of Appeal agreed. Can we just look at that, please? It's MS 133. So the upper tribunal says, we consider the non-negs failed to satisfy 23A and B. The non-negs, when returned or retained as winnings, are capable of being used to play a game, but that doesn't constitute them being used in place of money as payment for benefits. The benefit which a retained non-neg provides is no different from that referable to an original non-neg, for which no payment is required or made. There is accordingly no payment in money, which the non-neg can replace. The benefit of a retained non-neg can't be equated with that of a cash chip, for which payment in money would be required. And with respect, the reasoning of the upper tribunal in that paragraph is unanswerable.
Well, speaking for myself, I am struggling to understand it.
Well, let me explain it to you then, if I may.
Yes, please.
They're saying, look, the original non-neg was obtained for free of charge. It conferred rights, a benefit for which no payment was needed. And the non-neg returned as a prize confers exactly the same right. It confers exactly the same benefit. And it follows that it can't be said that a non-neg returned as a prize replaces the need for payment if the benefit conferred by it is one for which payment was never needed in the first place. So that's what it's saying.
But, well, help me then when one looks at subsection 3A.
Yeah.
You get a non-neg as a prize.
Yeah.
And ask, may it be used in place of money as whole or partial payment for benefits of a specified kind obtained from a specified person?
Mm-hmm.
Now, why isn't the ability to gamble and win money from the casino a benefit of a specified kind, the ability to gamble and win money from a specified person, the casino, and the non-neg can be used in place of money for that?
Because we've got to focus on the non-neg provided as the prize and say, well, are you using the non-neg to pay for benefits? Well, no, the non-neg, when first issued, conferred the right to play for free. And so the non-neg returned as a prize. Well, it confers exactly the same right as the original non-neg. That can't be paying for benefits if no payment was required in the first place. That's the reasoning of the upper tribunal, which we fully support, and indeed the reasoning of the Court of Appeal.
Yes, thank you.
And then, finally, I am aware of time. Returning to section 20, subsection 4, on MS 288, paragraph B provides that the second situation in which a voucher provided as a prize is to be treated as having no value is if its use in place of money as a payment for benefits is subject to some restriction, condition, or limitation, which materially affects its value. And as both the Upper Tribunal and Court of Appeal found, a non-neg returned as a prize also satisfies those conditions.
Could we look at that? Could we give us the references?
Yes, if we can go back for one last time to the Upper Tribunal's decision. This is MS 133, paragraph 50 of the Upper Tribunal's decision. And where the Upper Tribunal says, secondly, the use of a retained non-neg is restricted to the same use as any other non-neg, can't therefore have any different value in money or money's worth. As we've determined the value of a stake staked as a non-neg to be zero, it follows that the value of a non-neg representing a prize must also have a value of zero, which is significantly less than its face value. And once again, we would fully support the reasoning.
So I follow if the position is that because of non-challenge to Mr. Rothwell, we've got to proceed on the factual basis that these things are not assignable and have no value. I follow that might follow through.
Absolutely.
But if one were not in that position and they are assignable, but for some value which we don't know what it is it not right that your own paste necklace illustration, which is, as long as there's some value to it in the market, for the purposes of the calculation under section 1110, one reverts back to the value that the parties have agreed it should have, capable of answering the point on section 24B.
Yeah, I would have to accept that.
Because in substance, as long as the punter can say, well, there's some market value, and then turns to play the game, and then one's dealing with the contractually assigned value, which is the full face value.
I would have to accebt that's right.
It wouldn't be significant.
And you're right when you say that the consequence, the tribunal's conclusions on 4B are consequent on its conclusions on the value of stake staked.
Right, okay.
So you're right when you say that, yeah.
There's another point, isn't there, on 4B, and that is it is looking at subjective valuation, because it's talking about value of the voucher to the recipient.
Yes.
So the Upper Tribunal haven't taken account of that point.
No, they haven't, but they didn't need to, with respect, my lady, because once they had arrived at the conclusion that the value of a non-neg as a stake was nil, well, that was inevitably less than.
But it depends on that.
Yeah. So take your point, but they didn't need to. Is the answer to that? Might I just have?
Thank you.
unless I can assist your ladyship's further.
No, thank you very much indeed. Ms Belgrano, over in England. Thank you very much, Mr Perrott.
Yes, well, just a few points in reply. First, I mean, but my learned friend made this morning the point that a difference between a free cash chip and a non-neg is that with a free cash chip you could go home, you could use it in the bar, you could gamble with the chip, whereas with a non-neg you could not. Two points really in response to that. First, essentially a minor point, but an important, nonetheless one worth noting, is that when the casino gives a free cash chip as an incentive, it presumably hopes and expects that that's precisely not what the customer is going to do with it. Hopes that the customer will use it to gamble. But more importantly, and this is really our fundamental point, is that the player who decides to put a £100 non-neg chip down as a stake, whether assignable or not, whether he decides to put it down as a stake on a particular game, is, on any common sense approach, risking value. If on that game the player loses the non-neg, he bets on red and the ball lands on black, then he's lost all further chance to bet with that chip. It's disappeared, it's gone, he's lost it. And looking at the other side of the table, the banker is relieved from all further risk that that particular non-neg will be played in a future game in which it wins, and the banker has to pay out real chips with a real monetary value. So we simply reject the proposition that either assignable or non-assignable, a non-neg has no value. And since, as it's turned out, having heard from my learned friend this afternoon, that really the centre of his case, right at the centre of his case, is the claim that a non-neg has no value at all, because he accepts that as soon as it has value, the analysis becomes completely different. Since it lies at the very heart of his submission that a non-neg has no value at all, our observation that that is simply not a realistic analysis of what a non-assignable non-neg actually is. It is something with value. If somebody loses it, if it drops down the drain, they will think, I have lost something. I have lost something valuable. Just applying that sort of common sense approach just demonstrates that the proposition on which my learned friend's case now entirely depends, the proposition that it has no value, is on analysis just not correct. My learned friend took you to the Lipkin-Gorman and Aspinall's case. On Lipkin-Gorman, our position is essentially this. Lipkin-Gorman certainly does show that a cash chip is equivalent to money, but it doesn't help one analyse what a non-neg is. It simply wasn't a matter before the court. And of course, that is precisely the question before you today. The fact that a value, we know this from Lipkin-Gorman, the fact that we know that a cash chip is simply equivalent to cash with the same value as the face value of the chip really does not in any way indicate that the value of a non-neg with a value of £100 is zero. And my learned friend used the language of appropriation. He said, well, when a cash chip is staked, the casino appropriates it, his word. We say exactly the same is true when a non-neg is staked. The casino appropriates it in precisely the same way. The non-neg can't be staked on another game, and if the non-neg loses in that game, it's gone. And as I said, the casino is then free from the risk of losing against that chip in future. As for the way my learned friend dealt with the paste necklace case, I mean, again, and I'm to some extent repeating myself, at the heart of his argument on that was that the reason why a paste necklace is different from a non-assignable non-neg is that he says a paste necklace is worth something greater than zero, even if it's in fact worth very little at all. I pause at this point, since my learned friend, I feel the need to make this point because my learned friend places such emphasis on the difference between something being worth nothing and something being worth very little. Your Lordships actually go to a piece of evidence in the case at MS 264, where you see terms of a voucher. Can't help noticing that at the bottom of this page, one's told, right at the bottom, paragraph numbered 1 under free roulette straight bet, the value of this voucher is 1p. So it's slightly questioned whether it's correct to say that a non-neg has no value, given that on its face it's given a nominal value. But leaving that point,
that's your best point.
No. It's not my best point, perhaps, but leaving, because I couldn't slightly resist making it, but even leaving that point aside, the real problem with it is that it fails to grapple with the force of our point, which is that my learned friend agrees that where a paste necklace is worth very little but something, he then accepts immediately that the value to be attributed to it is the value agreed between the banker and the punter as to how it's to be valued, what the value is, its value is as a stake in the game. But there's a sort of radical, critical disjunction, because he says that's true right up to somewhere just south of very little, but as soon as it's worth, he says, nothing at all, the analysis becomes completely different. And it's entirely unclear to us why there should be that radical disjunction between something which is worth nothing and something which is worth very little. So we really have 2 points. One is that actually on analysis it's not right to say that a non-assignable non-neg is worth nothing. It is in fact worth something. But even if that's wrong and one regards it as being worth nothing, we simply don't see the legal basis of the radical distinction drawn by my learned friend between cases where an item is worth nothing and cases where it's worth virtually nothing or very little, or wherever it is my learned friend is drawing the line.
And I suppose you could say they both involve radical departure from the real world. It's just that one is worth 1p and the other is worth nothing.
Indeed. My learned friend's a position on assignability. Let me be clear what our position is, particularly dealing with the points made by my Lord Sales about how this court is supposed to deal with this point. My learned friend took the court to what the upper tribunal says at 34, which is, and the upper tribunal did say, and we accept this, that there was no evidence before it that a non-neg could have been assigned. And we accept that. That is, we haven't appealed against that finding, which is a finding of fact. And we accept that in these proceedings we're stuck with that as a finding. So we accept that the non-negs in this case have to be, we have to agree that as a matter of fact, they are not assignable. That said, and I make this point really with an eye to future cases, so that your Lordships are aware of how future cases might run. It's certainly worth noting what is actually said. My learned friend took you to the witness statement put forward by his clients, and at page 230 of the of the bundle. And we just invite your lordship just to have a look at paragraph 16, which I think my learned friend didn't take your lordship to. And there the witness says that there is no written contract, no written terms and conditions in respect of non-negotiable chips. And then he says the only reason for this is that the only condition attaching to a chip is that it cannot be encashed or exchanged for goods or services. It may only be used to place a bet at the gaming table. Now, it doesn't, we say that evidence is not immediately suggestive of there being a restriction on assignability, and it may well be that in other cases it can be demonstrated that the vouchers are indeed assignable. But that's we are where we are on the evidence, and as I said, we accept what the upper tribunal said at paragraph 34, and we haven't appealed from that.
Yes,
the real problem.
I thought it would be wrong for us to speculate about what evidence might be called in other cases involving different taxpayers.
What's important in this case is whether the question of assignability should be the hinge upon which everything turns.
But insofar as it is, you accept that in this case it is non-assignable.
That's right, it's not assignable.
Thank you.
But our fundamental point is that this is not the right hinge. And we say that for a couple of reasons, one of which is the question of whether a chip is actually assignable may not be entirely straightforward. It leads one into problems. As I said, that was one of the reasons I pointed your lordships to the evidence in this case. But I mean, one can imagine questions about whether the right test is whether it's assignable in practice or whether it's assignable legally. One can imagine a situation where a provision is put somewhere in the terms and conditions, but in practice it may be established that the casino turns a blind eye and has no particular problem if people start swapping chips among themselves in return, using my Lord Sales example, for a beer or whatever.
It would also make it very easy for the duty to be avoided.
Yes, indeed.
That would suggest that it might not have been intended as the hinge.
Indeed, and it sort of invites casinos to pop down a sort of standard form of wording as a way of avoiding duty, which is not...
Sorry, what would they be avoiding? I mean, if it's something they've produced and is not true receipt, why are they avoiding duty?
If it encourages them to put the words on the voucher to say this is not assignable, if the assignability is the hinge.
Yes, but I'm trying to understand what they're avoiding. I mean, basically the object of this is to find a way of taxing their gaming receipts.
Yes.
This is not a gaming receipt, but actually something they've given free. Why are they avoiding any duty?
Well, we say that's, this really gets back to sort of fundamental...
yes, I mean, the problem with all this, you're trying to sort of isolate a particular type of element in the sort of company's profits. It's gaming receipts, which are to be taxed in a particular way, while the rest of its profits and losses are being dealt with under the ordinary corporation tax. And so, not surprisingly, they're at the sort of boundaries between the two. There are some quite tricky issues. But at the end of the day, what this is about is trying to tax receipts in the real sense, but gaming receipts in the real sense.
I mean, the fundamental difficulty, a principle with assignability, which my learned friends call assignability is the hinge on which everything turns. It's really, and you know, I'm going to some extent going back on myself. It's really at the end of the day, it's not plausible to suggest that assignability is the difference between a non-neg with value and a non-neg without value. It's the point I made already in reply, that in any colloquial sense of what value means, somebody who holds a non-neg has something of value, and if they drop it down a drain, they have lost something, and that doesn't turn and that doesn't turn on the question of whether it's assignable. It may be slightly more valuable if it's assignable, but the proposition that it is only valuable if it's assignable is, we say, simply implausible. And indeed, there are many cases where one can, I gave the example of a vase in the British Museum or a ticket for the Olympic Games, things that are not assignable, but on which, if one was trying to work out whether the person who owned them owned something of value, the answer would be an unequivocal yes, despite the fact that it's not something that they can assign or transfer in the market. And here you have a non-neg is something which you can use, and as my example of the cautious betting strategy, you can use in a way that is very likely to get you real money back, perhaps not quite the face value, but certainly something which is very real and which you can go out and spend in shops. Finally, the relationship between the Betting and Gaming Duties Act provisions in Section 20 and Section 11. Your Lordships will understand that my clients are charged with trying to run the tax system and have a concern to make sure that it is internally coherent and consistent as it is possible to be, given what Parliament has done with it. They are therefore keen to interpret Section 20 in a way which aligns, to use the word of the moment, with the provisions of Section 11. But we certainly don't, we can't put the position any higher than that. The point made by various of your Lordships to my learned friend, that at the end of the day, your Lordships aren't bound by the fact that both parties want both provisions to be read consistently, albeit of course consistently in their own way, doesn't tie your Lordships' hands. Your Lordships could come up with a result in which Section 20 is read, where a non-neg has no value under Section 20, but does as a prize, but does have a value under Section 11. It's not impossible that the Lordships come up with that.
Your combined, your agreed position seems to imply that the necessary modifications to which 10 big A refer include a modification which says that this applies not just to prizes but also to stakes.
It is. I think our position is more straightforward than that. I mean, our position is if it just so happens that the way we think Section 20 ought to be read does in fact match with the section of
I see you say
provision.
It's just confirming you're what you're reading anyway. Yeah.
It has some value as a cross-check. One can't put it any higher than that because it's.
So you're not relying on any particular interpretation of modifications?
No, we're not doing that. Doing that.
Thank you.
I mean,
it's not just your the revenue's responsibility to administer the tax system coherently. It is actually a presumption of statutory interpretation that Parliament intends the state to be coherent.
Yes, it would be.
Well, obviously that's right, but sometimes it makes it rather difficult.
One hopes that what Parliament says makes sense, and sometimes one's disappointed.
I mean, I take the point on necessary modifications possibly going wider than just the prizes side, but subject to that, am I right in thinking that Section 20 is looking at the prizes side and not at the stakes side?
It is, absolutely, and as your Lordship points out, it contains a deeming provision for which there's no equivalent on the stakes side. Just a couple of points just arising under subsection 3. My learned friend made the point, essentially his point under subsection 3 is to say that because the original non-neg is given free, no payment is needed for it, when a non-neg is awarded as a prize, it can't be any different from what has been given free and therefore must be regarded as of nil value. So the difficulty with that proposition is this. I mean, these are provisions of general application that apply to all sorts of vouchers that are given. But you can imagine a supplier that sometimes makes supplies of, say, a holiday against a free voucher, but generally charges for them. It's a travel company. Generally you have to pay, but sometimes it will accept a free voucher. If there's then a voucher awarded for a holiday organised by that travel company, it doesn't, we say, make sense to say that that voucher has no value, because sometimes the supplier will give holidays free against a voucher. The answer is the voucher does have money, because normally what the voucher is used to purchase is something which is bought with money. And the same thing is true here. A non-neg that is given as a prize and is then used on the gaming tables is used to purchase something, the right to a chance of winning, which normally requires money. And the fact that sometimes what the non-neg gives you can be obtained by using a freely awarded non-neg is irrelevant. What matters is that what the non-neg given as a prize is used for, and as I said, the fact that normally what it is used for is something for which you have to pay in the usual way when you go into a casino and buy chips. So that's really our answer to my learned friend's point under subsection 3. And as for subsection 4b, I think my learned friend and I are on common ground that really the analysis of that subsection really stands or falls with the arguments that on which we addressed your lordships under section 1110A, and really that section adds nothing. So those, my lords, are my submissions in reply, but if there are any further questions, of course, I'm happy to deal with them.
No, I think you've covered the ground. I'm sorry we've made it a little more difficult for you at certain points than it might otherwise have been. But thank you all for your work and your enormous help, and for those behind who've also put their input, and we'll do our best to come up with a coherent solution. Thank you very much.